On March 1st, the federal government started requiring title companies to report your private financial information every time you buy a house through an LLC or a trust, every single transaction, not because you did anything wrong, because they decided the entire category was suspicious. That lasted 18 days. On March 19th, a federal judge in Texas looked at that rule, looked at the law, and said, FinCEN, you do not have the authority to do this. Rule vacated, nationwide, and nobody explained to you what just happened. Until now. I'm Bill Rosenblatt. I am a licensed attorney and a licensed real estate broker. And this is The Legal Broker. Before we get into it, nothing in this video is legal advice. I'm not your attorney. Laws vary by state. If you need guidance specific to your situation, talk to a licensed attorney in your jurisdiction. Let me set the table. In August of 2024, the Biden administration finalized something called the Residential Real Estate Reporting Rule through FinCEN, the Financial Crimes Enforcement Network, which operates under the Treasury Department. The rule took effect December 1st, 2025, but FinCEN delayed the reporting deadline to March 1st, 2026. Here's what it required. Anytime a residential property was transferred without traditional financing, meaning a cash deal or a seller finance deal, and the buyer was a legal entity like an LLC or a trust, the reporting person, usually the title company or the settlement agent, had to file a detailed report with FinCEN. We are talking names of beneficial owners, addresses, the transfer amount, property details, all of it going into a federal database. FinCEN estimated this would generate 800,000 to 850,000 reports per year. The compliance cost between $428 million and $690 million in the first year alone. And those costs were going to land directly on buyers and sellers through higher closing costs, anywhere from $472 to $829 per covered transaction. Now here's the part that matters to you. If you own rental properties in an LLC, which a lot of you do, or if you hold property in a trust for estate planning, which many of you should, this rule treated you exactly the same as a money launderer, not because of anything you did, because of the structure you used, the legal structure that attorneys and accountants specifically told you to use. This is not about catching criminals. This is about the government deciding that an entire class of ordinary transactions is inherently suspicious, and that should concern every property owner watching this. So what happened in Texas? A family-owned title company in Tyler, Texas, called Flowers Title Companies, filed suit against the Treasury Secretary with the help of Pacific Legal Foundation. Their argument was straightforward. FinCEN exceeded its statutory authority under the Bank Secrecy Act. On March 19, 2026, Judge Jeremy Kernodle agreed, and he did not mince words. The court struck down the rule on two independent grounds. First, the Bank Secrecy Act authorizes FinCEN to require reports of suspicious transactions. The key word is suspicious. The court found that FinCEN essentially declared all non-finance real estate transactions involving entities to be categorically suspicious without any individualized basis. The judge called that explanation, and I'm paraphrasing here, vague, conclusory, and unpersuasive. Second, the court found that the Bank Secrecy Act only authorizes FinCEN to require financial institutions to maintain reporting procedures. It does not authorize FinCEN to impose independent, substantive reporting obligations on parties like title companies. Because the rule conflicted with the plain text of the statute, on both grounds the court vacated it entirely under Section 706 of the Administrative Procedure Act. Not enjoined, not paused, vacated, gone, nationwide. But here's where it gets complicated. 1 month before the Texas ruling, a different federal court reached the exact opposite conclusion. In Fidelity National Financial versus Bessent, the U.S. District Court for the Middle District of Florida, Judge Wendy Berger upheld the FinCEN rule. The Florida court found that the rule was within FinCEN's statutory authority, complied with the APA, and was consistent with the Bank Secrecy Act. Same rule, same statute, two federal courts, opposite answers. Now technically this is not yet a circuit split because no appellate court has ruled. But when two federal district courts in different circuits reach opposite conclusions on the same federal rule, That conflict almost guarantees this issue is heading to the appellate courts. FinCEN has publicly acknowledged the ruling and stated that reporting persons are not currently required to file real estate reports and will not face liability while the order remains in force. But the government has options. They can appeal to the Fifth Circuit Court of Appeals. They can seek a stay of the pending that appeal, which would temporarily revive the rule. Or they can go back to the drawing board and write a narrower rule that might survive judicial scrutiny. Given the conflicting rulings, I would expect an appeal. And given the current administration's posture on deregulation, the timeline and appetite for that appeal is genuinely unclear. If this ends up at the Fifth Circuit, you are looking at a court that has been skeptical of broad agency authority. If it eventually reaches the Supreme Court, we are in major questions doctrine territory, which is the legal principle that agencies cannot assert vast regulatory authority on ambiguous statutory text. I will be covering every development in this case as it happens. So what should you do right now? 1. If you are a property owner using an LLC or a trust, you are not currently required to report under this rule. Flowers is in effect nationwide. 2. Do not dismantle your compliance infrastructure if you are a title company or settlement agent. This could come back on appeal or through a revised rule. 3. If you are considering forming an LLC or trust for real estate, this ruling does not change the analysis on whether that structure makes sense for you. Talk to a licensed attorney in your state about your specific situation. 4. Watch the Fifth Circuit docket. I will keep you updated right here. Here's the bigger picture. This case is not just about one reporting rule. It is about how much power federal agencies have to regulate your property transactions without clear authorization from Congress. The federal court in Texas drew a line. The federal court in Florida drew a different line. And until an appellate court or the Supreme Court resolves this, the legal landscape is genuinely unsettled. That is exactly the kind of legal friction this channel exists to explain. I am Bill Rosenblatt. I'm the legal broker. If you want to understand the law behind the headlines before it hits your closing table, subscribe. I will see you in the next one.